Okay, so as we start to welcome everybody back from our short break, I'm going to go ahead and introduce our speakers for segment 2 and then pass it over to the moderator. So for segment 2, our moderator today is Ankita Dhawan, who is an Indian lawyer at Ikigai Law. Next, we have Kirkying Chu, who heads the Intellectual Property and Technology and Dispute Resolution Practice Group at Wong & Partners, a member firm of Baker McKenzie. We then have Christine Ng, who heads the IP Valuation and Strategic IP Department of Adastra IP. She is also an IP licensing director with Life Sciences Oman and is serving a third term as Secretary General of the Business Valuers Association of Malaysia. And last but not least, our male along with the female partners is Izwan Zakaria, who is a technology startup and venture capital lawyer at Izwan Partners. So with that, I will go ahead and pass the floor over to Ankita, our moderator for this session.
Hi, everyone. Hi, Chelsea. Hi, panelists. It's been a really interesting morning with Mauricio and the other panel talking about some of the really interesting aspects of the SDC. And I think one key takeaway that I had from the previous session was that there is really no one-size-fits-all approach. And what the SDCs really should be, viewed as is not like a one-stop solution to sort of all your possible legal disputes, but it should be looked at as a way to, sort of cover all your bases. These are the clauses which are important, how you customize them and how you, sort of tailor them to your business is really up to you. And I think, sort of going forward with that theme, I had a few questions in mind when I was looking at, the SDCs myself, when I was helping the AIAC edit some of the clauses. And I think really that's the kind of questions I will be posing to the panelists today. And I can perhaps just throw questions, at the panelists, and you can pick them as we go if that's okay with everyone. Okay, I'll get started now. I think one question, which comes to mind is about the ownership of a software. And I think we discussed scope of work in the first session, but I think if you just take a step back and really talk about who owns the software, what is really, the ownership structure, and how is this issue, dealt with legally is to my mind a really important question.
Hi, Ankita, Kirk here. I'll be quite happy to jump in for this one. So I think ownership is really one of the core issue that is faced by both customer and developer. It is usually one of the more negotiated clauses. And in the SDC itself, of course, the ownership clause has already been provided for. And perhaps I just flag out some of the key points on the issue of ownership that is provided in the SDC. Yeah. Now, the key points is number one, all existing IP, that is of each party continues to belong to each party. So the ones we call background IP, typically that's quite standard, will continue to belong to each party. As provided in the SDC, the customer will have ownership over the developed software and all deliverables. Yeah, so that is that basis as provided in the SDC. Is of course if parties negotiate otherwise, then of course this will then have to be amended. Now, what is also important ownership is also this for the developer. The developer also warrants, at least as provided in the SDC, that the software and deliverables does not infringe any third-party rights. This is also a very typical warranty that you see from any software developer. But the issue I would like to flag out to developers is also this. Yeah? If there is use of open source software to help develop or is utilized in the development of the software, it needs to be looked at carefully. Yeah, because as the developer may not be able to pass full ownership of full IP ownership, we call it, of the software to the customer, and sometimes may even have restrictive licenses, okay, in open source software. Okay, so that is really important to flag. There is also a provision in the SDC for use of open source software, but that needs to be tied back to the ownership issue, because if that is used, it may impede the transfer of the whole ownership of the software to the customer. Now, the second issue, which I want to raise vis-a-vis ownership of software, also more to the developer and also the customers, is whether the software that's delivered, or eventually delivered, will still need to ride on a base software. And that base software, as I started, the first point is that will still be ownership will be retained by the developer. That means if the delivered software, okay, cannot fully function without the base software that belongs to the developer, then there needs to be discussed, that perhaps a license of sort would need to be granted alongside with the customized and developed software. So these are some of the ownership issues I just wanted to flag up. Back over to you, Ankita.
Thanks, Ms. Chu. I think this is a really interesting analysis of ownership, especially with regard to open source softwares. And I think what comes to mind then is what happens if the software is customized. So what is the ownership status in case if customized softwares? Are customers allowed to make changes to a customized software or to improve on them, or to sort of come up with better softwares? What happens to IP in those cases? And then how does the contract address issues on what can and can't be done with source codes and sort of post development sort of issues?
Maybe Ankita, before perhaps Kirk takes over to continue, just a few notes that we'll add in as well, and is basically will dovetail into your questions about improvements and future developments or derivatives of the custom software. So I think what makes sense for a developer would be the fact that what makes commercial sense is that developers are able to make money from their for their background IP. So as Kirk pointed out, that there will be pre-developed source codes, for example. So it is important for developers to have control over this, because it makes sense for them to work on it for future projects. So if we are going into this a project as a custom software, I'm very sure that there will be a substantive part of the source codes or the modules that will be an existing module. So this is where, again, this contract software, the standard software contract allows for the specification of what are the IP rights that is pre-existing that will not be included to be given to the customer. So making sure that the developers are specified accordingly. So this is where there's going to be considerable time spent to specify the technical documents, so that they will be very clear in terms of what would be finally owned by the customers and what ownership can be retained by the developers, so that they will then, it makes commercial sense for them to not every time have to write new lines of codes for different customers. Okay, so to answer the questions about what you brought up is customers for whether they are allowed to, how much they can do. Yes, definitely. I think this is an important aspect of any customer when they spend a significant amount to custom make a software. So they will definitely have rights to make changes. So again, bringing up what Kirk mentioned is about third-party software as well. So if a developer integrates third-party software, they also must specify the rights to further changes. So it must be specified as well, so that as a customer, when they take over and run and operate the software in the future, they'll be very clear in terms of what the rights they have, not only to the rights of the software they have paid for, but also in terms of how does it impact and what rights do they have in terms of making changes where there are third-party integrated software in it as well. And going back again, to this standard forms, the important thing would be perhaps to also specify potential development. So I'm speaking from the perspective of someone that has been on the other side of the fence as a customer, then I would want to know what would be the potential upgrade. So, you are always looking at upgrading, because sometimes if you are launching a major software, you will definitely foresee some kind of upgrade. Or if you're operating in an industry or an environment that's very fast paced, then, you're probably looking at making changes every 6 months or 1 year. So, having something in mind, planning forward in terms of future derivatives or future improvements or version 2.0 will be critical to just capture in perhaps the appendix part of the contract.
Thanks, Ms. I think this is also really helpful. I think I can't help but wonder, just taking a step back and trying to understand the human element of the intellectual property aspects that you've discussed. So behind every sort of ownership issue, it's critical to also sort of have clauses about the right people. If they can just leave your company, start another one, develop similar contracts, etc. So I also want to understand what is it that the SDCs say about non-solicit clauses, and maybe it'll be nice to have Mr. Zakaria's inputs on this.
Thank you, Ankita. Again, thank you so much for having me. I probably be the least experienced person here compared to the other two panelists, but again, I work a lot with entrepreneurs and startups. So obviously, from a contractual leverage standpoint, I would say we generally, as legal counsel, defending the underdogs. The guys that finally got their breakthrough, or finally got a large company that decides to appoint them as a software developer. So obviously, one of the big challenges, like what you raised, Ankita, is how do we navigate in a scenario where, and that's probably which is quite ironic, because the most amount of time that should be spent will probably be on the scope work. But one of the big commercial risks that a lot of these guys have to address most of the time is how do I avoid or reduce the risk of my existing key talent being poached by a larger client. In this case would be the customer, and in this way, obviously different jurisdiction will have different position when it comes to non-solicitation, but the SDC provides clearly that the customer would ensure that there will be no poaching and solicitation. But ultimately, obviously, in practice, it is inherently challenging for the customer, for the developer in this case. If you're running a small company and your talent is being reached out privately, and how do you make sure that you can even match the offer from a larger business? But SDC does provide non-solicitation, but obviously in Malaysia as well, it's also a gray area as to whether or not non-solicitation can even be upheld, and that's another thing. So I wouldn't say it's a legal risk, but more of a business commercial risk that the developer needs to continuously manage as and when they embark on signing new engagement.
Got it. I think the situation in India is also fairly similar, if I may add, that there's some kind of sort of legal provisions that have an overarching sort of impact on non-compete and non-solicitation clauses, and therefore it's very important to, when adopting the STCs, find out the local law of the land and just make sure that you're compliant with that. And obviously, retaining the best talent is the cornerstone of all tech businesses. So that's definitely elemental. Another element which I think is absolutely important for such businesses, and this also again stems from having the right people, having the right IP, is confidentiality. And I know that the previous session also touched upon this a little bit, but I just want to understand, what are the confidentiality requirements under the SDCs, and what impact do different data protection laws across different jurisdictions have on these? So for example, if I'm a business sitting in India, or a business sitting in Malaysia, or a business sitting in, say, Singapore or the US, will there be differences in how the confidentiality clause is looked at based on the different laws? And naturally, I don't want to sort of go into the details of these laws, and how they're different from each other, but just understand what can the parties to contract factor in, when they're deciding on these clauses, and what measures can they adopt when making sure that they're compliant with the local data laws as regards to the SDCs.
Let me jump in for this, Ankita. Yeah. From my perspective, I always feel that the confidentiality clause is always often kind of like overlooked, kind of like everyone accepts that, okay, it's there, but I think it's quite important to take a close look at it for both parties, especially the SDC has covered it quite well. So there is a certain amount, as we know, when the parties come together, there's a certain amount of confidential information that will be shared, obviously. Yeah. For example, the customer, they will likely share confidential commercial information, yeah, because they need to provide that to enable the developer to understand, look at the needs, to make sure that they create the software that's needed. And from the developer side, they also may be sharing a lot of technical aspects of the software, yeah, which will be delivered. Now, so a few points that I would just want to highlight when it comes to the confidentiality clauses that was provided in the SDC itself. The first is that the obligation extends to ensuring that employees, not just employees, okay, any third party involved, yeah, in the contract is subject to the same obligation. Yeah, so something to bear in mind, because some parties may just assume that it's just them. So if you're the developer, if you bring in any third party to help out, yeah, you must remember that that obligation extends to the developer, ensuring that those third party are also subject to the same confidentiality obligation, which means that a separate NDA will likely need to be signed by these employees or third parties. So that is the first point I want to highlight in terms of the confidentiality clauses in the SDC. Secondly, it also should be noted that the obligation survives the termination of the contract. Okay, so that means notwithstanding that the contract ends, yeah, the obligation of confidentiality survives. Obviously, I think that's important for both sides. Okay, so I think those are a few of the highlights I want to highlight on the confidentiality clause. But Ankita, you touch a bit on data protection as well. Yeah, so I just want to highlight that a little as well, because that is also provided in the SDC, yeah, in terms of compliance with our data privacy law. Now, in terms of those clauses, I would advise users to really go through those obligations for data privacy obligations carefully in the SDC, yeah, and also amend where needed. Yeah, the first point is that for the customer, the SDC provides that the customer gives consent to the developer to process the customer's personal data to perform the contract. Okay, it's important to understand that, because this means that the customer must themselves ensure that the personal data which they hand over to the developer has the necessary data subjects consent as well, because this will be a third party. They will need to see that whatever they hand over, they themselves already have obtained the necessary consent for them to hand it over, disclose it to the developer, and for the developer to process the personal data. So that is an important point, can be overlooked as well. Now, on the issue of data privacy for the developer, yeah, the developer under the clause provided in the SDC is obliged to destroy the personal data once the contract is completed. So sometimes this is overlooked as well, because you just assume that, just go on because contract is handed over. Remember that because of the data privacy laws in Malaysia, so there is an obligation by the developer then to destroy that, because the purpose for which it was used is no longer there. Therefore, they should cease to not to use it, yeah, unless further consents have been provided, which likely they would not have secured those consents. So something to remember as well. Another point for data privacy is the developer also has the obligation to implement appropriate technical measures. Okay, this is also provided under Malaysian data privacy laws, and some of these details are set out in Appendix 11 of the SDC. So for developers using the SDC, please do look at it carefully, because that is your obligation to make sure that the technical measures are provided. Yeah. And the last point I want to touch on for data privacy is, which is provided in the SDC, is that if there is any data breach, yeah, whereby then the personal data, of belonging to the customer is disclosed, the developer is required to notify the customer within 2 days, okay, with details of the data breach. So this is important because under current Malaysian data privacy laws, there is no such obligation, no legal obligation to notify for data breach. But this is imposed under contract because a lot of the data privacy laws around the region do actually have what we call data breach notification requirements. So that is actually provided for in SDC, even though it is not under Malaysian law. Yeah. So something just to flag up for data privacy provisions. So back over to you, and Kita.
Thank you very much. And I think just to give you some Indian context about also data privacy and reporting of data breaches, I think we're also revising our law. In fact, a new law about data protection is likely to be passed this month, if not the next month. And I think what we're all really waiting for is provisions that tell us what to do in case of data breaches. So I think it'll be really helpful if businesses adopting these contracts around the world are aware of their responsibilities and liabilities. And, they have a privacy by design policy, which is to say that they know really what has to be done in case, a breach occurs, and they don't really go with the approach that, oh, you know what, it's just data, we'll see when it happens. So I think that's hopefully an important approach that businesses should look out for. Another thing that you mentioned is technical measures, and I remember the last session also touched upon some of these technicalities, especially when discussing the scope of work. It's very important between sort of customers and businesses to sort of just sit down across the table and figure out the technicalities and the exact scope of work. But I wonder what happens in case of a scope creep, where typically there can be major changes to the scope and the deliverables of the software in the middle of a schedule. So, so if you have, as a part of this panel, also any suggestions or any sort of comments about this.
Yeah, I can provide some thoughts, because I've been on both sides of the fence as a developer and also as a customer. So scope creep it happens in all projects. So it's just a matter of the degree of it. So before we talk about the variation, so under the existing standard forms, the variation order comes under clause 9. So, but before we even start talking about variation order, would be the fact that it must be based on the fact that there is a beginning understanding of the scope and deliverables. So as you rightly mentioned, significant time is very tedious, but to sit down both parties to scope it out. So once the scoping is done, the deliverables is understood, and preferably there should be some documentation in the beginning, so that when it comes to the variation discussion, then there would be some reference. Because if not, means you can foresee and you can anticipate a lot of disagreements between the developer and the customer. So variation order, as I mentioned, that it should be significant enough to be considered as a variation. So of course, as developers, and they would be savvy enough, seasoned developers would make some buffer in terms of what they can, take in extra. And of course, for the customer side, we would, of course, want to expect the developer not to basically come down to haggling over every tiny aspects of thing. So I think with that spirit in mind, just understanding that there will be changes and some flexibility inbuilt in the scope, okay, would be a very good start, and subsequently to agree on what constitute as a variation. So I think in the beginning, if there is a statement provided, or it's very clearly stated in the scope of deliverables and what constitute as outside of the scope, will provide a basis for the variation order in the clause 9.
Got it. Thanks. There's actually a follow-up question from the audience here. I'll just read that out to you. It says that the clause on variation appears to only provide for variations that are agreed by both parties. does the contract not allow one party, and I'm specifically thinking about the customer, to unilaterally vary the scope, and of course with appropriate compensation? The customer may have circumstances that may need them to change the scope and may not want to end up with something that is not fit for their purpose.
I think I saw something about Chelsea wanted to answer this question, but I just add in a little bit. Yeah, so at the end of the day, I think the critical thing is about understanding what the customer wants. Sometimes it is unintentional that a customer may need to just put a brakes on everything and really significantly overhaul the software. I think at that point, I'm quite sure that even for the customer, it's not a decision that is arrived easily, because there will be costs involved. So the real life answer to this will be, yes, if there is a basis to just abandon everything and just relook at the whole thing, I think it's something that a decision needs to be made. But of course, the customer needs to know that there will be considerable costs involved. Okay, they need to understand that as well. So the second point will be that if this happens, then whether or not the original agreement will be sufficient, or does it cover then the ongoing obligations and rights of both parties, and will there be a revamp, of course, again in the understanding of the original terms. Yeah, so there will be subsequent negotiation, I'm very sure.
Thank you very much. Chelsea, would you like to add anything? We saw that you had volunteered to answer this question.
I just clicked that so the other attendees could see it, but so I will let the panelists answer. I only clicked that just so everyone could see the question.
Okay.
All right, thank you very much. I couldn't help but pick on a very, very important theme that you mentioned just now, and that's obviously money, because that's really why all businesses exist. So payments are obviously such a crucial part of any of these contracts, and like you rightly said, even when you're sort of getting into varied scope of works, etc., the crucial element is the payments, the money. So if you could just throw some light on the payments clauses and how those work in the SDCs, and what are the points the businesses should take into account when looking at these clauses.
I'm happy to let the other two answer.
Happy to pass to each one.
Mr. Sakaya, would you want to take a shot at this one?
Well, Ankita, the terms on the payment, obviously payment is like cash flow is the lifeblood of a business, right? So right now in the document, it's quite blank because the parties need to decide on the payment, and obviously these are all boils down to the commercial aspect of I mean, again, it boils down to the contractual leverage, right? In our scenario, where we always advise on the developer side, we always tell them that you need to get at least initial upfront so that you have some visibility in terms of cash flow, and even in the payment terms, again, like what Ms. Chu repeatedly mentioned, please spend some time to read the 47 pages document. It's actually very well drafted. I mean, for us practitioners, we're always looking for a good base document to work with, and I think this could be one pertinent point that many of the participants will benefit if you are a practitioner that deals with daily drafting for your client or your employer for that matter. So and obviously in terms of payment terms, there's a clear mention of 30 days, and obviously in your payment cycle, if it's not acceptable, again, if you're dealing with a large corporation, probably 30 days will be too short, will be too long. Most of the time you're looking at 60, 90 days. And again, another point to also highlight is that there could be different procurement policy applicable depending on the customer that you're onboarding. But again, in most situations, if you're dealing with large corporate, they'll probably have their own document. So we're looking at mostly medium-sized kind of outfit. So to answer Ankita's question, the payment terms obviously we don't, in the SDC did not include in specific milestone or percentage. So it really boils down to the parties to iron out. And this again goes back to the initial point that I think the first session, I think Thomas and the other panelists have spoken extensively together with Patrick about the scope of work, right? I think a lot of the time people want to start the project and they really just put a one-liner. I think it does make a lot of difference to spend some time on the granular details of the scope of work and the deliverable and the milestone. And I think Patrick mentioned good analogy earlier about building a car, but I think if you dealt a lot with construction contract on a fundamental level, the software development is quite similar, although we're talking about intellectual digital asset, where things we can't see, but ultimately the scope of work and deliverables are important because it sets out the architecture or the infrastructure in terms of how you want the final license software to look like. Because in payment standpoint, your remuneration as the developer is tied to the completion of the specific deliverable. So long as you're clear, and because ultimately the customer will need to sign off and ensure that the actual deliverables have actually been met. And if you're dealing with sophisticated or experienced customer, then obviously that reduces the risk of conflict or dispute. But if you're dealing with first time or not so typical customer, then that's where the challenge would be. So please, and because the payment in the SDC is tied closely to the milestone and the scope. So please make sure that the scope and the payment are in line so that you don't end up scenario where you run out of money or the work is done but the money is coming later at certain tranches and so on.
Great, thank you. That's very helpful. So I think by now we've discussed scope of work, we've looked at payments, we've looked at intellectual property, we've looked at confidentiality and non-competes and non-solicit clauses. I also want to understand, just beyond these, sort of usual suspects, these sort of super important clauses, there are some smaller clauses, which are often ignored, but are also really important to, they're really the lifeblood of the contracts. Some of these are the obligations of the customers and the developers. So if you could just throw some light on what these obligations of customers and developers are.
Sorry. Go ahead.
Okay, yeah. So I mean, for my side, the obligations, I think basically these are smaller points, but I want to link it to an important, sort of journey or the phase or the stage of life cycle to a software. So obligations for the developer and the customer would be, of course, to be number one, I mean, the spirit of ensuring that the project is successful. So to disclose, to provide technical information, because sometimes as a developer, a lot of times, or I would say half the time, the developer would have technical knowledge, but they would not have industry or subject matter knowledge. So, making sure that there's the correct disclosure of what is required for the subject matter functionality will be an important obligation. When I say obligation, meaning that just because a customer pays for it, they cannot also expect that the developer would immediately overnight become a subject matter expert in the particular industry where they are operating in. So the obligations of providing data, because these are all critical information that will slow down a development project if there is no subject matter perspective being pumped into the project. Because at the end of the day, it's like, putting bricks together. So writing source code is like putting bricks together to build a structure. If there is no direction, then, you're talking about, where do I put the bricks, how thick would be the wall be? So this would be a similar analogy. To me, it's very important because having all these small issues that you talk about, because at the end of the day, a lot of times a custom software sometimes become a very, very important asset of a company. So a lot of people don't have that in mind. So it is a software. But then once a software is being successfully deployed and a customer starts earning revenue, build reputation, build credibility, build the entire business around a specific software, for example, it becomes a very, very valuable asset. So if you look at some of the statistics that is provided by industry studies, a lot of companies now are basically measured, the value of the company is measured by intangible assets. And a lot of it, you study the background of it, the statistics shows that asset-light companies such as software companies or companies that runs basically on predominantly digitally or virtually, they don't have physical assets, then their software, their brand, the technology becomes extremely valuable. So if you are looking into transacting your this intellectual property rights or even the software, there's a lot of activities in terms of sale of software, assignment, licensing, mergers and acquisition. So a lot of M&A activities have taken place for the very fact that small companies are basically very valued for their entire platform. It's a platform application together with their key manpowers, their talent. So these are, there's a lot of very high acquisition activities, based on software applications. So when that happens, a valuation is done, for example, or there will be transaction, there'll be due diligence behind it. So when they start doing due diligence and they start digging, then that's where the whole ownership, the whole agreement, licenses, what is agreed, what is allowed, what is not allowed, what constitutes as part of the software to be bought and sold. Just like, as a property, if you are looking at having a house, so your title, you will want to be very careful. What are the encumbrances that comes with it, limitations, before you can actually transact. So don't get caught at the end, at the point of, when your software becomes valuable, then you realize that there are lots of holes and, restrictions in terms of what you can or cannot do with software, because it becomes then the lifeblood of the company.
Thank you so much. Is there anything else that you want to add, Ms. Chu, to this?
No, not really. I think Christine has covered it very comprehensively, but maybe just to highlight that in the SDC, the obligations of the customer and also the developer has been set up very clearly. And it is so important for whichever the user is to go through them carefully, because those obligations will then form the basis of, sorry to say this, but basis of any breach. Yeah. So they need to know and understand what they have agreed to, what the obligations are. For example, in the SDC, for the developer, there is already obligations that they will develop the software that will conform to the agreed requirements that was already set out in accordance with the payment plan, for example. There is also obligation for them to provide adequate security measures that when we talk about to safeguard the deliverables. There is also obligation on them to also provide the specification for testing. Yeah, so these are quite detailed and all set out in the appendixes as well. So I think it's very important that they look through them and agree that those are the obligations that they decide to take on, and similarly for the customer as well. Back over to you, Ankita.
Thank you. I see that we're almost at time, but we have two questions from the attendees. So maybe I can quickly pose them both, and then the panelists can decide which one they want to answer respectively. The first question is, how can payment be best structured in agile software development, given that milestones may be hard to define, given the agile nature of the development process itself? The second question is there any appetite, possibly in future, for the contract to be written in plainer language? Oh God, I really wish that were the case. I'll go out of a job, but definitely. Language that ordinary customers and developers would understand more easily. By plain language, I mean that language that complies with plain legal writing guidelines followed around the world, like Australia, New Zealand, Canada, some states in the US, and even the UK. Wow, I want to read some of these contracts. It's written in plainer language. But, over to you guys. You can decide which ones you want to answer.
Yeah, maybe I'll comment on the second question. I think there is a trend towards, of course, simpler English and plain English, we call it, in terms of contracts. And that filters through, I think, yeah, you're right. And whoever is asking the question that in Australia, and in particular, that is the trend. But what I can see is that perhaps, especially for more consumer-facing contracts, there have been a greater drive to make those contracts more what we call simpler. And I think banks have been required to do that So I'm aware that financial institutions have revamped a lot of the contracts because they're dealing with a lot of consumers to make it all is a direction from Bank Negara as well for the contracts to be simpler so the consumer can understand it easier. So I think it's a matter of time, but to be fair, sometimes not everything can be in simple, super plain English, only because also as a lawyer, we know that the courts have taken certain interpretation of certain clauses. Yeah, therefore, the drafting of those clauses may have been comprehensive if it's done in a particular way. So I think so there has to be a bit of a balance. I think on this one sense, simple, clear English is fantastic. At the same time, it must also be sufficient to cover the risk of each party. I think that would be my response.
Anything else that anyone else wants to add? I'm sure this
Yes.
is a panel favorite question.
I'll just quickly add, because I think we're also running out of time. I'll just quickly add that, there's the question about the payment in terms of milestones. Milestones may be a bit, so for example, in the case of agile software development, I think at the end of the day, I think a customer will release money based on what they can see, right? So I think this is where, if milestones is a bit difficult, because you are going to have changes in terms of, for example, timeline. So timeline, it's not so much about my milestone is according to 1 month, 3 months. So at the end of the day, I think what would work best in the circumstances where there's very quick reaction to what is needed for software will be to demonstrate some kind of deliverables. So if you structure to show something that, okay, I'm going to have a total of, for example, 4 payments, and these 4 payments will be on condition of showing something to the customer that we have done this, this is working, and we are progressing to the next step, I think would be something that will can be, in a way, what would be the payment structure in answer to the question. I don't know whether it helps, because that's quite a general question. And then I think there is an earlier question at 10:45. Developer is an entity that employs developer. So that it's a straightforward thing that if you are in employment, okay, whatever work that you produce belongs to the employer. So a simple answer to that is any software developers or any employer should ensure that it is very, very clear in their employment contract.
Thank you. Thank you very much. I think we're at time now, a little over time actually, but thanks a lot for your time, everyone, and for all of those insightful takes on different clauses of the SDCs. Over to you, Chelsea.